Good evening, everyone. My name is Kevin Butterfield. I'm the Executive Director of the Fred W. Smith National Library for the Study of George Washington at Mount Vernon. You are coming to us for our monthly Ford Evening Book Talk, sponsored by the Ford Motor Company, and an event that we have been doing for years, and one that now is sadly in an online-only format, but that opens up whole kinds of new possibilities for us. We're able to have conversations of the sort that we've not had before. And tonight we get to actually have two wonderful Americans joining us to have a conversation about the Constitution. We're going to be joined by David Rubenstein, a leading businessman and philanthropist, and Judge Douglas Ginsburg, who is also the creator of an important new series on the Constitution and a companion volume. David Rubenstein is, of course, a household name here in Washington, D.C., where I'm coming to you from, a leading businessman and philanthropist, founder of the Carlyle Group, and someone who has been intimately involved in helping to support patriotic institutions around the region and around the country. Mount Vernon among them, but also Monticello, Montpelier, the National Park Service, monuments and memorials all across the city and across the nation. One of the things that I'm excited about in this conversation is that these two men actually attended law school together, and they'll be chatting to you not simply as fellow Americans, but as people who have known each other for quite some time. And David Rubenstein will be interviewing a man named Judge Douglas Ginsburg, who has served on the U.S. Court of Appeals for the District of Columbia since 1986. He is a man who has been an important part of the conversation in this country about the importance of our own constitutional knowledge and our own awareness of our civic responsibilities. A man who has clerked for Justice Thurgood Marshall, has been a professor at Harvard Law School, is now currently a professor at George Mason University at the Antonin Scalia Law School, and a visiting professor at University College London. It's my great pleasure to bring both David Rubenstein and Judge Ginsburg together for this conversation. I hand it over to you, Mr. Rubenstein.
Thank you very much for that kind and overly generous introduction, and thank you very much, Doug, for doing this. I should tell everybody that I'm able to call him Doug Ginsburg, not Judge Ginsburg, because I knew him about 45 years ago or so when we were in law school. I was in the same class, but not really in the same class. He was in a much different class because he was a superstar law school student, and I was not. He clerked for Judge McGowan, one of the best judges in the D.C. Circuit many years ago, and then for Thurgood Marshall when he clerked in the Supreme Court. So, Doug, it's an honor to be with you and to talk about a subject that you obviously know a lot about, the Constitution. Let me just start by asking you, when did you start getting interested in the Constitution? What is it, in law school or when you became a judge?
You were there, David. It's when we were in law school. We studied constitutional law. I'd had one course in college, but it really didn't ignite my love of the Constitution until we went to law school together.
So the book we're going to talk about is Voices of Our Republic, which is a companion book that this book has been edited by Doug Ginsburg, but it's a companion to a TV series on PBS called A More or Less Perfect Union, which is about the Constitution. It took you how many years to put that series together, Doug?
About 3.5 years. Yeah.
And so when you put that together, the companion book talks about people's views of the Constitution.
Right.
And I found it quite interesting. I highly recommend it. But what I'd like to do today is to go through the Constitution, how it evolved, why it is interpreted certain ways by judges and so forth. So why don't we just start by something that has always been interesting to me. It seems as if in our country, the Constitution is almost a religious document. People swear an allegiance to the Constitution, whereas in other countries, maybe they swear an allegiance to a particular government. But here they swear an allegiance to the Constitution, and it has a kind of a religious tone to it. And the founding fathers, those who drafted it, are seen as almost religious icons. Why is that? And is there any other country that observes the Constitution of its country quite the way that we do in this country?
Well, our Constitution is uniquely central to who we are as a nation and as a people. More so, I think, and more revered than the constitutions of other countries, many of which, around the world, many of which were modeled on our Constitution pretty closely, although much more rarely followed as closely. But, you know, most people, even though they revere the Constitution, have not read the Constitution. It's a very brief document, and it's not hard to read. It was meant to be read by the public who ratified it. So when they talk about it with as you said, reverence, for the most part, what they're really thinking about is the Bill of Rights, and in particular the First Amendment. That's what people are most familiar with. Their right to speak freely without reprisal from the government, to have religious freedom, to worship as they please. Those are the things that really resonate with almost everybody in the country.
So the Constitution is now about 230 years old. Is there any other constitution in the world that we know of that is still extant after that long a period of time?
Well, the only other written constitution that's as old, indeed older, is that of Massachusetts, which was 1780. Of course, ours was written in 1787 and ratified in 1789. Now, the British Constitution, most people don't realize. They say, well, it's not written. Most of it is written down. It's just not codified in one place. And of course, it's a good deal older.
Now, at the Constitutional Convention, which we'll talk about in a moment, Thomas Jefferson, the author of the Declaration of Independence, was not there. Many people think he was involved in the Constitution. He was not there. But in correspondence with James Madison, he apparently said, we should only have this last 20 years, and maybe every 20 years we'll redo it. And many of the founding fathers who were at the convention thought it wouldn't last quite this long. Is that right, more or less?
Well, they certainly didn't have the hubris to think it would last for centuries. But they did hope that it would last a good deal, a great number of generations, and that's why they put an amendment process in it, to make it responsive to future problems that they knew they could never anticipate. So
the Constitutional Convention had, I think, roughly 55 to 59 people there, given they came in back and forth and so forth. There weren't that many that signed it. We'll talk about that in a moment. But they were all white males, property owners, all Christian. There were no women, no minorities, nobody Jewish, nobody from the non-property class. So is it not interesting that we have this reverence for this document that was drafted by people that today, if you had a Constitutional Convention of people who are all white male property owners who are Christian, you would probably say, we're not going to listen to that. Isn't that kind of surprising? Have you ever thought about why we revere something that was drafted by people today? We wouldn't want such people to draft something like that.
Well, if you think back over the history of inclusion of blacks, of women, of Jews, of immigrants from all over, what they wanted most was to be a part of the Constitution, to be represented in the Constitution and protected by the Constitution. There was a, 50-year campaign for female suffrage, for women's suffrage from 1870 to 1920. Blacks were constitutionally given the vote in 1870 with the 15th Amendment. It took almost 100 years to really make that realistic in all parts of the country. But it's what people most wanted. And when they came here as immigrants, later on, large numbers of Jews, people from all over in different religions, and people from Asia and Africa, well, they came for to be under our Constitution. That means secure property rights, freedom of religion, freedom of speech, political representation. So of course they revered it because that's what they came for.
So are you surprised that all the amendments to the Constitution, we have 27, we'll go through the amendment process in a moment, but all 27 went through the process where you have 3/4 of the states approving it and 2/3 of the House and 2/3 of the Senate. But the Constitution also says that you can have a new Constitutional Convention that could be held. Why has that never happened? And do you think if one were held, the Constitution we'd get out of that such a convention would be dramatically different than what we have?
Well, I certainly don't think it could be as good as what we were given. Now, if we haven't adhered to it as closely as we should have done, I don't know that a constitutional convention could repair that. But as you well know, education in civics and history in this country has really fallen to a very low level. And not only have most people not read the Constitution, but particularly young people are ignorant of our history and of civics generally, as well as their own role in things. I would fear for the Republic if there were a constitutional convention today because of that ignorance.
So let's talk about for a moment the interviewees that you interviewed as part of this book, Voices of Our Republic. You interviewed, or others did as well, people who had their comments on the Constitution, famous people, not famous people. What was a common theme that came through the interviews about what people think about the Constitution?
Well, we wanted to have these comments, and there were about 80 of them, from a very diverse and wide-ranging group of people. And we accomplished that. They have different perspectives, different backgrounds and experiences. They don't all agree with each other by any means. But the thing that they have in common, all of them, is their understanding of the centrality of the Constitution to who we are as a people, and something they've thought about, and in many cases experienced, either because they came to this country from elsewhere, or because they've worked as journalists who are acutely aware of their protection under the Constitution, Supreme Court justices, but also creative people, musicians, writers, who again are quite keen to be aware of the Constitution because of the fragility of their rights in other countries. We have people who were the descendants of major constitutional figures, the great-great-granddaughter of Justice John Marshall Harlan, the great dissenter of 130 years ago. Someone who, in her family, was brought up with this.
So if somebody said, look, I don't have time to read the whole Constitution, and frankly, I don't even have time to read your book, but I have a minute or so, tell me the key message that you would like to convey to people watching about the Constitution, the key message after all your years on the court and all your study of the Constitution.
We were given a very carefully considered and balanced written Constitution. It was a novelty in the world, except for Massachusetts. And we have failed to live up to it. We have allowed the Supreme Court to play fast and loose with it. We've allowed the Congress to escape some of its responsibilities under the Constitution. We've allowed the executive, the president, and the executive branch to accumulate vast powers being delegated by the Congress. So the branches are out of balance, and that's something that could be redressed with an alert public that cared about this.
So let's talk about how we got the Constitution. So when we fought the Revolutionary War, we had 13 colonies, and the 13 colonies were loosely governed by something that became known as the Articles of Confederation. So when we won the war and we signed the Treaty of Paris in 1783, we're governed by the Articles of Confederation. What was wrong with the Articles of Confederation? We won the war with the Articles of Confederation. Why not just keep them?
Well, they didn't make us a nation. We were a confederation of 13 sovereign states, and a loose confederation. The central government could not impose taxes. It could not raise an army. It depended entirely upon the voluntary contributions from the states. The deficiencies were really apparent to everyone. There was no dissent on this proposition, because the states put up trade barriers so that they issued their own money. Goods could not move freely across state lines. One state's fishermen couldn't fish in another state's waters. That impoverished the country, and we were in a prolonged depression. We couldn't defend our shipping. It was preyed upon by France and Britain at sea. And the precipitating event was Shays' Rebellion in Massachusetts. This was a rebellion of farmers who were veterans of the Revolutionary War. The federal government could not pay their pensions, and these were legitimate grievances, but there was no way to redress them. And in fact, the federal government couldn't put that down. It was private citizens in Boston who financed an army to put down that rebellion. 6 months later, the Constitutional Convention began, because everyone knew it was a crisis.
Now, the principal proponents of the Constitutional Convention were some well-known people, James Madison, Alexander Hamilton, among others. They thought the Articles of Confederation were not working for the reasons you just articulated. But the most important man in the country was George Washington. He had been the winning general during the Revolutionary War. He wasn't really saying we should have a constitutional convention. How did they persuade him, and who really persuaded him to not only come to it, but also to support the Constitution once it was drafted?
Well, in terms of coming to it, I'm sorry to say I can only imagine. I don't know, but I think it was probably James Madison. The delegation from Virginia were very prominent people in the Commonwealth: George Mason, James Madison, George Washington, and a couple of others. They all knew each other. They had all served in the Revolutionary War and in the Virginia government, almost all of them. So I don't think it took a lot of persuasion for George Washington to participate. And he ended up playing and I think everyone anticipated he would play a very important role just by being there, by supporting the Constitutional Convention. He was very quiet. He was elected the presiding officer, and he sat up on the dais and presided. But if he needed to say something to represent Virginia, he stepped off the dais, a new presiding officer took over, and he went to the Virginia delegation seats and spoke from there. So that when he was completely dispassionate when he was on the dais and presiding.
So under the rules that they set up, they said, as I understand it, there's nobody supposed to talk about what goes on here. It went on for 4 months, I guess May to September.
Right.
Isn't that kind of unusual to have 50-some people, no leaks at all for 4 months? Can you imagine that happening today?
Absolutely not. And there was not a single leak. That was extremely important. You'll see in the TV series, I spoke to Dr. Franklin about it and General Washington, and as Franklin said, so we could change our minds as the discussion matured, and so not to be portrayed as flip-floppers.
So, of course, they didn't have any air conditioning then, but they were afraid of keeping the windows open because people might listen to what they were saying. So they were sitting there unair conditioned in the Philadelphia summer. That was pretty difficult, I imagine.
It was a brutal summer, actually. So it was a great difficulty, a great burden on all of them. And not everyone persevered. Some people, as you said earlier, came and went.
Now, there was an official note taker who was supposed to be taking notes of what happened, but he wasn't apparently that good at it. So how do we actually know what happened at the Constitutional Convention?
Well, the most we know comes from James Madison's notes. And the notes are not entirely complete. And worse than that, Madison altered the notes to some degree later in life. So we don't have a complete account. There are letters and recollections from other people who participated later on writing this down. But in terms of contemporary notes, it's primarily Madison's notes, as imperfect as they are.
Now, Madison was the person who is often called the father of the Constitution. But why is that? Because he really didn't write the words so much, and many of his main ideas were not adopted. His main idea, as I remember it, was to have the House and the Senate both be proportionally represented according to population and not have what we now have. So why was he called the father of the Constitution, since his main idea, the so-called Virginia Plan, wasn't adopted?
Well, the Virginia Plan also, though, entailed having these two different chambers. I mean, granted, both would have been based on population. And a third branch. The theory of political philosophers from Montesquieu through Locke really spoke in terms of an executive and legislative branch. And Madison created the idea of a third, more or less co-equal branch of the judiciary, designed simply to keep the other two branches in their lanes, as it were, to adhering to the limits on their powers. That there would be limited and enumerated powers came from Madison, or in his Virginia plan. Now, the fight over representation was a very important and central matter. And the simple fact is, as brought out by Dr. Franklin, that the small states would never have consented to be entirely at the mercy of the large, more populous states, Virginia, New York, Pennsylvania, as opposed to New Hampshire and Maryland and Delaware. They would never have agreed to it. And remember, they voted as a state. 9 states had to ratify this convention for it to go into effect. And those states never would have done it. So we got this idea, this compromise of one house based on population and the other based on just being a state, and each state treated equally with 2 senators.
So one of the things that they came up with was how you get elected president of the United States. We now know, of course, that it was the Electoral College. Was that always the method that they wanted to have, or was that a last-minute invention?
Well, they discussed a number of possibilities. Of course, there was a little bit of royalist sentiment, primarily from Hamilton. There was long talk of a plural executive, a small council, but they decided that in the interest of efficiency and energy, a single person could make decisions and could be held responsible. So they settled on a single person. And then the Electoral College was meant to reflect this balance between the House and the Senate, because each state got as many electoral votes as they had representatives in Congress, based on population, plus the 2 for the Senate. So it was sort of a consequence, I think, of deciding that the 2 houses would be differently constituted.
So one of the provisions of the presidency is that the president would be commander-in-chief. Was that because everybody thought that George Washington would be the first president and he was a general, so they called him president and commander-in-chief? Or why was the president given that title as well?
Well, everyone did anticipate that Washington would be president. But I think the main impetus was so that, again, there could be a single person who could make decisions and could be held accountable for them. If you had a president on the one hand and a commander-in-chief elsewhere, there would be room for finger pointing and slippage and ambiguity about who was really responsible.
Now, the most infamous decision made or not made there was what to do with slavery. The word slavery never appears in the Constitution, but they had an infamous decision that a slave was worth 3/5 of a man, I guess. Was that something that the Constitution could not have been come together if they had proposed to get rid of slavery? And how much was slavery debated as part of this whole Constitutional Convention?
Slavery was the intractable problem. It was quite clear that the southern states would not participate, would not sign on to a document that abolished slavery. They did succeed in agreeing on ending the slave trade after a set number of years. The word slave doesn't appear in the document because it was such an embarrassment to the ideals of the Constitution. So we have references to other persons and to persons in involuntary servitude. But let me just make sure your viewers are clear on one key point here. The 3/5 clause, which provides that the population of a state would be counted one person for one white person, 3/5 for each black person, or each slave actually, was not a way of diminishing the personhood of the slaves. It was a compromise between the slave states, who said they should count as one, they're part of the population, and the northern states, which said, well, you're not treating them as persons, you're not treating them as part of the population, they should not be counted at all if you don't give them representation. And that's how they ultimately compromised on 3/5. The Constitution is nothing more than, well, it's much more, but it's certainly central to it are major compromises. The Senate House compromise, big state, small state compromise, the slave state, free state compromise. At least we wouldn't have had a constitution otherwise. Now, one consequence of counting the slaves as 3/5 meant the great overrepresentation of the South in the House, and therefore in the Electoral College, and 5 of the first 7 presidents are from the South.
So one of the decisions they had to make is who's actually going to write this document up. They have many debates over 4 months or so, but a committee on style was selected. And I guess the head of that was a man named Gouverneur Morris, who's not that well known to the general public. But is he the man who actually wrote the language, "We the people," and among other things, he actually came up with the language that's in the Constitution?
Joseph Ellis, an historian I think you know, was in the TV show, and I will quote him: "When you read the Constitution, you're reading Gouverneur Morris." Right. He was the chair on the Committee of Style, and he played an important role in making the document as precise and as inspiring as it is. And to give you the prime example, the draft that was given to him, in which there was general agreement with regard to all of the important institutional decisions, began by saying, "We the people of," and then listing the 13 states. And it was his idea to change it to "We the people of the United States."
Now, he was a man that had a disability, and he overcame that. What was his disability?
He lost a leg in the Revolutionary War. But he was a very sharp lawyer, a very great stylist, and we owe him a great deal.
So as they're getting tired after 4 months, they want to go home and so forth. They finally get ready, and at the end, one or two people get up and say, I think George Mason was one of them, a person whose law school named after him that you teach at. He said, "Hey, I'm not signing this. There's no Bill of Rights." Is that true? And why did he wait to the last minute to say there should be a Bill of Rights? And why is there no Bill of Rights? Why was there no Bill of Rights initially?
He said he would rather cut off his right hand than sign that document without a Bill of Rights. Now, Mason was one of the leading anti-federalists. Remember, one of the great issues of the Constitutional Convention was, well, how much power would the states cede to the new national government? The problem with the Articles of Confederation was that the states had all the power and the central government none. So it was a matter of degree. And the anti-federalists were those who wanted to limit the national government more strictly than came out of the document. And then no Bill of Rights. So he was particularly offended by that. Now, the anti-federalist idea of a Bill of Rights was not like the Bill of Rights we have. It included those individual rights and freedom of worship and so on, but it also included such things as no standing army and returning the control over the navigable rivers to the states, not the federal government.
So there's a man who gets up, the father of the Constitution, James Madison. He says, no, we don't need a Bill of Rights. And he basically convinced everybody to go forward and sign, except for those that, like George Mason, who won a Bill of Rights. So isn't it ironic that the father of the Constitution was initially the man who was against the Bill of Rights? Is that true?
It's true, and he was not the only one. Jefferson as well. They had correspondence while Jefferson was in France. And at one point, well, the problem that they agreed on, that all of the people proposed to a Bill of Rights, was very simple. We could never enumerate all the rights that our people are going to have. They have the right to marry or not marry, to wear a hat or not wear a hat. It would be ridiculous to try to enumerate all of those rights. And if we enumerate the most important ones, as ultimately happened, the implication will be that the others aren't protected. And we want to avoid that implication. They fought a revolution so that they could have the rights of Englishmen, and they weren't going to give them up by implication.
Now, the oldest man at the Constitutional Convention was Benjamin Franklin, the only man to sign the Constitution, Declaration of Independence, and the Treaty of Paris. And at the end, when he's leaving, it's maybe apocryphal, tell us if it's true or not, he walks out and somebody says to him, "What have you given us, Dr. Franklin?" And what does he say?
He said, "A republic, if you can keep it." And those were very ominous words, because the framers of this Constitution, the leading men, were close students of history. Madison, in particular, studied for a long time preparing to come to Philadelphia. Jefferson in Paris, our ambassador to Paris, was sending him all of the works of political theory that were available, all of the books on the subject. And the history was clear. Republics were short-lived. there had never been a successful republic that really endured for the ages. And the key to this republic would be that it would be protected by participation of the citizenry, that there would be many factions. It was an extended republic, as they said, across a huge territory with a very diverse economy, diverse people, different regional interests. They would keep each other in check and would only do things on which a majority, and in many cases a great majority, a two-thirds majority, could agree. It's very easy to lose that.
So this is not a violent overthrow of a government. There is an existing government operating under the Articles of Confederation. Yeah. But here are these people, these kind of people who came together as delegates. They have this Constitutional Convention. They come up with this Constitution, and then they send it to the Articles of Confederation Congress and said, you know, why don't you consider this? Why didn't the Articles of Confederation Congress say, hey, we don't want to redo the government. We like what we have. And what did the Articles of Confederation Congress do when they got this document from George Washington?
Nobody liked what we had. Everyone knew it had to go. And so the document was sent out to the 13 states for ratification.
And how many states did it have to ratify out of the 13 to make it work?
Well, it would require 9 to go into effect. But if only 9 had signed it, there would be gaps along the Atlantic coast in which there were no states. There was just there was a holdout state, not part of the Union. But the ratification process was by no means guaranteed to succeed for the reason you touched on: no Bill of Rights. And the ratification was going to go down in Massachusetts. Governor Hancock was chairing the ratification convention there, and he came up with the winning formula. So let us ratify this with the understanding that the first Congress will add a Bill of Rights. And that's what they did, and then several other states followed, and that put it over. And then all the states ratified.
Now, one of the states that was maybe not going to ratify, ironically, was Virginia. The governor of the state, Patrick Henry, was dead set against it. And so James Madison argued in their ratification convention for it. And in the end, because Patrick Henry was so upset with Madison for proposing this Constitution, he prevented Madison from being a senator. Senators were supposed to be picked by the legislature. Madison gets elected to the House, barely. And then when he's in the House, he feels a commitment to write the Bill of Rights. So is it clear that as soon as he got there, he started writing a Bill of Rights to be attached, and everybody said it's a good idea, or did they not really want it?
Well, first bear in mind, Madison had been against it in the Constitutional Convention, as you said, and he got gerrymandered into an anti-federalist district in Virginia. So they definitely wanted, his constituents wanted a Bill of Rights, and to get elected, he had to say, I will bring you a Bill of Rights. When he got to the House, he solicited from the public at large through the newspapers suggestions for what should be in the Bill of Rights. I think he got a couple of hundred. He narrowed it down to 12. And those 12 passed the House. It was not easy for him to persuade the House to really give him floor time to debate this and to ratify, to approve them. And then it went over to the Senate. And again, Madison had difficulty getting the Senate to pay attention to this, to give floor time for the debate over approval. They were, all 12 were approved by the two houses and sent out for ratification again by the public, by the states, pardon me, and only 10 came back. 2 were not ratified by the public. 10 came back. Again, he received suggestions from the anti-federalists for the Bill of Rights, but he didn't include them. He didn't include no standing army. He didn't include no jurisdiction over the navigable rivers. He picked the ones that he thought were most congenial to a democratic republic.
So there were 2 amendments that were not approved. So the Bill of Rights that we now know of, which was sent to all the states for approval, if you look at it, actually has these amendments that were not approved. As they were the first 2. One of them had to do with representation, but the one that was known as later as the Madison Amendment, the 27th Amendment, what was that and why was that so controversial?
Well, by the way, the First Amendment wasn't the first one because there were 12, but I think it was third. second
Right,
or third.
right.
So in a way, we're fortunate that it came in first. But the 27th Amendment, you know your history very well, David. The 27th Amendment provided that, pardon me, one of the two that didn't get passed, and then later was passed 200 years later, provides that no member of the House can be elected again if they've received a pay raise without, let me see if I get this exact.
Without there having been
Pay raise
intervening
cannot go into effect until they have gone back and been reelected.
Right.
So basically, if they want to raise their pay, they have to submit it to the voters.
And the reason that was not approved, as I understand it, amazingly, was it wasn't that people were against the idea of members doing it that way, but some people in the country said, we don't want these members of Congress to ever get a pay raise before the election or after the election. We don't want them to ever get a raise. So actually, that's why it didn't get approved. But ultimately, the 10 amendments are approved.
It lay dormant for 200 years. Pardon me?
So the 10 amendments are approved. The Bill of Rights is part of the Constitution. But interestingly, Madison's idea was to have the Bill of Rights incorporated into the document so that when you read the Constitution, the Bill of Rights was kind of in there as opposed to attached to it. Is that right? And why did he want to do that?
Well, it was a wise decision not to do that ultimately, because not only are they coherent and separate, because they deal with somewhat different subject matter than much of what's in the original Constitution, but the important thing that came out of their being separate like that is that, well, let me just back up a second. When Madison wrote to Jefferson and said, I've changed my mind, I'm in favor of a Bill of Rights, of course he'd been gerrymandered, he said, I don't think it will do any harm, and if it causes the public to revere the Constitution, it will do much good. Well, that's exactly what happened. The public reveres the Bill of Rights. And if they had been scattered through the text, there wouldn't really be a Bill of Rights for people to latch on to.
So the Bill of Rights becomes part of the Constitution. Everybody's happy. They're going forward. And then all of a sudden, there's a Supreme Court case known as Marbury v. Madison, Madison then being, I guess, Secretary of State.
Yes.
That became, I guess, maybe the most famous case in the Supreme Court's history. Why is it so famous?
It's the most important case in the Supreme Court's history, I think. And I said that in the show, and I read a little excerpt from it, because Chief Justice John Marshall, the great Chief Justice who served for 30 years, wrote that we have a written Constitution for a reason. It enumerates the powers of the branches, and particularly of the Congress, so that when a court can hold up a law or a document to the Constitution and ask, is it authorized? And if it's not, it's void. And that becomes the way in which citizens are able to vindicate their rights and keep the government within its lanes. Remember, the Constitution doesn't govern us. It governs the people who govern us. And so this concept called judicial review, being able to say this law or this executive decision is inconsistent with the Constitution and therefore void, is what protects us from the excesses that might otherwise have survived.
Now, the first Chief Justice of the United States was John Jay. And interestingly, as I've read it, he was the Chief Justice, but he was also doing diplomatic missions for the president, and he was also practicing law on the side. Can you imagine that today, where you're practicing law while you're also a Chief Justice?
Well, these institutions were all new. There was very little precedent. We know them today as we see them, but they were quite different then. The Supreme Court had very few cases in the early years. John Jay and the second Chief Justice each resigned after a couple of years. So Chief Justice Marshall was the third to preside. And he built the institution. And he was an ardent Federalist, and the decisions consistently favored the national government over the states for that period. So it was Hamilton referred to the judiciary in the Federalist Papers, which were essays in the newspapers trying to persuade people to ratify the Constitution, referred to it as the least dangerous branch. And it surely was that. As one of the justices says in the program, we have neither the power of the sword nor of the purse. And what does a court do when it makes a decision? It issues a piece of paper called a mandate, and we hope that the people will abide by it. Now, if they're individuals, the U.S. Marshals will enforce it, but we can't force the Congress or the president to comply with it. They've just done so.
So I think there was one president, was Andrew Jackson, who said, "Well, that's the Supreme Court decision. Let him enforce it," because
Yes.
it's not that easy to for the judges to go enforce these things. They just have to do it by the spirit of the country going along with what judges think is appropriate, I guess.
And 120 years later, that was around 1830, and 120 years later, when the Supreme Court decided that Brown versus the Board of Education of Topeka, Kansas, and said that public school segregation was unconstitutional, President Eisenhower received conflicting advice as to whether to enforce that mandate. His political advisor said no. The Attorney General said, yes, you must. And the president, of course, did.
Now, the Supreme Court has 9 justices. Was it always 9? And was there a plan to actually get it to be bigger than 9 at one point?
Well, there were 6 for a while. There have been 10. It's been 9 since the Civil War era. But that's not in the Constitution. The Congress can change that. So in 1937, I believe it was, President Roosevelt was very frustrated by the Supreme Court having held several of his New Deal legislation unconstitutional because it exceeded the authority of the national government, particularly with regard to the Commerce Clause. He was seeking to create regulatory agencies and passing statutes that would regulate things that were essentially local, like labor relations or mining. It was 1935, pardon me. And that went to a vote in the Senate. His proposal was to increase the number of members of the court by 1 for each justice who was over the age of 70. Of the 9, there were then 6 over the age of 70. The court would have become one of 15 justices. He couldn't remove anyone because the Constitution gives all federal judges life tenure. But that was such a revolutionary concept. In the Senate, where there were 96 senators at the time for 48 states, and I think there were a little over 60 Democrats, the president's party, that proposal got 20 votes.
So
it was simply inconsistent with our being a republic that we would change such a thing as that. That the 2 branches could basically make irrelevant the 3rd branch.
now there's some debate, but not too much, about what was the worst decision the Supreme Court ever made. And what would you say, in all the long years of the Supreme Court, the worst decision they ever made?
Well, I'm sorry to say that it's a hard choice. The worst one, though, has to be Dred Scott, 1853, a case that unquestionably hastened our decline into civil war. 57, I think. Dred Scott was an enslaved person in Missouri who was taken by his owners to Minnesota, a free territory. And when he returned to Missouri, sued to claim his freedom. He had been in a state where slavery was not recognized. And under the Missouri precedents at the time, he had a good case, he and his wife, Harriet. And I should say, in the show, this is all explained by his descendant today, who heads the Dred Scott Memorial Foundation in St. Louis. It went to the Missouri Supreme Court changed their precedent and said he was not free. It went to the Supreme Court of the United States, and by a vote of 7-2, they held that he was not only not free, having gone into Minnesota, but he could never be free, and an African American could never become a citizen of the United States. This was absolutely without any foundation in the text of the Constitution. It was the worst example of making it up to suit your preferences. It's happened a few times in very important cases since then, but none as disgraceful as that.
Now, for some people in the public, they think that judges are very political. And in fact, some people would say, well, if you're appointed by a Democrat, you're going to do whatever the Democrats want. If you're appointed by a Republican president, you're doing whatever the Republican president wants. Is that a fair way to look at what judges do? And do you think judges, when you make decisions, is it the political considerations that weigh into it, or is that nothing that really matters to you?
Well, it certainly isn't for me, and I don't think it is for my colleagues. That is basically a canard that the media repeats day after day based on the decisions. They don't say it, they just ignore that when they get to decisions that are inconsistent with that, when the mix of judges on one side and the other of a particular case do not reflect one political party versus another, or the president's parties. 40% of the Supreme Court cases are decided unanimously. So I've served with a little over 30 other judges. I don't think that has been true of any of them. But what accounts for the media perception is that a lot of times judges are asked specifically whether something is reasonable. Well, what seems reasonable to one person is going to differ from what seems reasonable to another. And if you bring different experiences, different life experiences, different background to the court, and the courts are quite diverse in this respect, you're going to have differences of opinion about what's reasonable. And they are going to often align with whether one was a conservative person before becoming a judge or a liberal person before becoming a judge. That doesn't go away, but that's not partisan. That's a different or deeper difference between perspectives.
Now, you've been a judge for more than 30 years, and you were for a while the chief judge of the D.C. Circuit. So when you're a judge and you want to get somebody who's another judge to go along with you in your way you think they should decide the case, do you ever say, if you vote for me on this case, I'll vote for you on... That happens all the time in Congress. It doesn't happen in the courts. That never happens, does it? Or does it?
I have never... not only said that, I've never heard that. That would be regarded as a very severe breach of fidelity to the Constitution.
Do the judges ever say, okay, forget I'm going to vote for you on another case, but look, I need a favor here. Can you vote for me on this one, because this is important to me, and I really want to do this. Can you help me? I need a favor. Do they go lobby each other, or they don't do that?
What happens is that after the case is argued, the judges have a conference. In our court, it's immediately after the 3 arguments of that morning. In the Supreme Court, it's on Friday at the end of the week of arguments. And we sit down and discuss the cases. In both courts, the most junior judge on the panel, or in the Supreme Court, or they hear the cases with all 9 judges, the most junior judge or justice speaks first. And when everyone has spoken, there can be back and forth and argumentation and trying to persuade one another. When I was fairly new on the court, it was 1987. I was on a case with Judge Bork and Judge Mikva, and it involved whether a juror had a principled objection to a case, or whether he just disagreed with the law. And we spent 2.5 hours pulling down books off the shelf, trying to resolve that question, looking at the precedents, discussing them. We couldn't do it, by the way. We ended up having to reverse the trial, and a whole bunch of people had to be retried. But no, it's a much more of a scholar's discussion than a political discussion.
So let's suppose I have a case before you as a judge, and I say I want to win this case. Does it really make a difference what lawyer I hire? And if the oral argument is spectacular, is that going to change a judge's point of view, or it's really not that relevant how articulate the person is in court?
Well, the oral argument is it's sometimes decisive. It's very often important. I say that because very frequently all of the judges, some or all of the judges, come to the oral argument. They've read the briefs, they've discussed them with their law clerks, And there are some things that they need to get clarified about the arguments, or that they'd like to see narrowed because they want to say to the lawyer, look, you're making this argument, but that would have all of these implications for other cases, and it would really be a very broad ruling. Don't you think that this more narrower ground would make more sense? Try to bring a bit of a concession from the lawyer to clarify and narrow the case. So that's an important function. Sometimes there's a genuine ambiguity about what the lawyer means. So oral argument can be very important. It's not in every case, but it can be.
So there's an argument about the Constitution and how to interpret it, and much of what judges do in the constitutional area is interpret the Constitution's meaning. So let's go through the different schools of thought. There's a school of thought some would call originalist, known perhaps because that's what I guess Justice Scalia called it. But that means you're interpreting what the original meaning of the Constitution was as the founders drafted it. Is that right? And why is that a good way to look at things?
It's searching for the original meaning of the Constitution as the people to whom it was addressed at the time, those who ratified, those who wrote it, those who ratified it, would have understood it. Much as you would ask in a contract, how did people understand the words when they were written? Or if you're listening to a play by Shakespeare 400 years ago, you'd want to know, some of those words have changed a lot. You'd want to know what they meant to the author and the public at the time. That's what was agreed to. And the alternative, the so-called living constitution idea, is one that authorizes courts to alter the meaning of the Constitution from what it originally was. And judges are the last people who should be amending the Constitution. There's a process for amending the Constitution. It takes a supermajority, as you described it, 2/3 of each house and 3/4 of the states, and we reserve that for very important questions. And it's really not playing by the rules for the court to change the words. And I'll give you a very simple example. The Takings Clause of the Fifth Amendment, part of the Bill of Rights, says that property may be taken by the government for a public use with just compensation, which means fair market value, basically. Well, what's a public use? Public use has always been understood to be a highway, a school, a post office, things that that eventually railroads, perhaps, because they transported the public and they had to get a right of way. In a recent case, a dozen years ago, the Supreme Court said, well, this project in New London, Connecticut is okay. The city council condemned all these properties. They're taking them. They're paying the people what they're worth because they want to clear the land so that a private corporation can build a campus here and a mall developer can put up a mall. And that'll yield more tax revenue for the city. The Supreme Court said, well, that's a public purpose, and therefore it's okay. We know it's a public purpose because the city council approved it. Well, public purpose is not what the Constitution says. Of course, you could call that a public purpose, but it's not a public use. And that kind of playing fast and loose with the Constitution wording is inconsistent with the idea of having a written Constitution. And the result was 46 states changed their law to make it clear that they were not going to be doing this to their citizens.
So since the early 1970s, since the Roe v. Wade case, perhaps the most contentious issue over the decades that gets to the Supreme Court in terms of constitutional interpretation is the meaning of abortion, what's permitted or not, so forth. But if you take an originalist point of view, there was no discussion of abortion at the Constitutional Convention. So how does originalists kind of come up with a conclusion about what abortion should be, and how does a living document person coming up with a decision about what's appropriate?
Well, the way the Supreme Court did it as a living document, sort of majority at the time, was to say, well, the Due Process Clause of the Constitution, which is all about procedure, has a substantive component, and we will tell you what it is. And they've done that on 3 or 4 occasions since then, in very important cases also. The original answer is quite clear. The federal Constitution doesn't address this. It was left to the states. And when Roe versus Wade was decided, about a dozen states, it was the height of the first wave of the modern women's movement. and women's liberation, if you will. And about a dozen states had changed their laws to relax them, to liberalize them. Many states were in the process of debating that, and a few states had decided not to. That process was underway. As Justice Ginsburg, Ruth Ginsburg, pointed out in a speech at NYU some years ago, this decision truncated the political process. It stopped the discussion. And that's why we've never had peace on this subject since then. 23 countries, well, there's a wonderful book called Abortion and Divorce in Western Law by Marianne Glendon at Harvard. 23 countries changed their laws on this subject and on divorce in a short period of time. 22 did it by legislation. In legislation, there's always compromise. In the Supreme Court, somebody wins and somebody loses. And that's a very unsatisfactory way to resolve something like this. Compromise is the way that it's resolved most successfully.
So if you had been at the Constitutional Convention in 1787 and you had the opportunity to make any changes, what would you have recommended that they do differently than they did?
Well, if I had all power, it would have been to end slavery. As a realistic matter, of course, that many of them wanted to do that, probably a near majority, but that just wasn't practical. I think I would have tried, I'm not sure how, to prevent the rise of political parties. They didn't exist at the time. The idea of factions was much derided as being untrue to representing your constituents. But political parties emerged early in our history, and they've been with us ever since. And now, party politics is dominant, and that is not the best thing for our republic and for our people.
So suppose you had an opportunity to have dinner tonight with one of the people who helped draft the Constitution, let's say Madison or Gouverneur Morris or Alexander Hamilton. What would you like to ask him?
Well, that's would be a long dinner, I would hope. I think I would probably ask Madison in particular. If he had the benefit of our 230 years of experience under the Constitution, I would ask him what could he have done better, and doesn't he agree that it would have been that it was better to have the two houses differently composed than it otherwise would have been? I mean, he would have, I think, admitted to been proud of a lot of the Constitution and admitted some regrets in other respects.
Now, judges are not highly compensated in our society. In fact, if you clerk on the Supreme Court, the day after you clerk, you get a big bonus and a big salary. You make twice or three times what the Chief Justice makes, and you're just a young lawyer. What is it that made you want to be a judge for 30 plus years? Obviously, you've given up enormous financial amounts of money you could have made as a lawyer or other things. What is it that motivated you to want to be a judge all these years? And any regrets about spending 3 decades plus being a judge?
Certainly no regrets. When I was asked whether I wanted to be considered for the Court of Appeals, I had never thought about being a judge. I had to ask my colleague at the Department of Justice to give me a week to think about it, discuss it with my wife. I then came back to him and I said, I'm leaving the country on government business for the next 10 days. Don't count me out. While I'm away, please, I want to think about this further. But I had already committed to an academic life. I was just on leave from Harvard, where I'd been teaching for 8 years. And so I decided, well, what am I going to do when I leave government? I can't stay here. I'm a political appointee. When the president's term is over, I'm gone. And I decided I would go back to Harvard to teach. And so comparing that to being on the court, you don't have to teach a particular course. You get 3 terrific law clerks instead of 150 students who are, some are great, some are not. And an unending line of interesting cases that require real thought and real work and of service to the country.
So let's suppose somebody is watching and they say, I am impressed with this man's knowledge of the Constitution, I would like to learn more about the Constitution. I'm not going to be a constitutional law scholar, but what can I do to learn more about it? What would you tell somebody to do? Watch your PBS series, read your book? What should they do?
I think the very first thing is to go to freetocoosenetwork.org/Constitution. freetocoosenetwork.org/Constitution. You'll see there the 3 episodes of the series that can be watched free of charge, and my 2 interviews, one with Dr. Franklin and one with General Washington. They are entertaining as well as enlightening, and they wouldn't have been on public television if they weren't. It showed in 3/4 of the country in the last several months, and then when school children were sent home, it was put on again among the programs in the school day afternoons for children to watch, high school and 7th and 8th graders. It'll be on Amazon Prime soon. Again, of course, free to anyone. And in Constitution Week in September, it'll be shown all over again. Start with that. If that doesn't pique your interest, nothing will. If it does pique your interest, read the Constitution and then look at the book. There are a lot of different ideas by different people. 5 justices of the Supreme Court, the publisher of the New York Times, Ted Koppel, Jack Nicklaus, people whose names you know, but maybe didn't think that they had thought about the Constitution, and they have. And that will stimulate your thinking about it. And it will affect the way in which you read the papers or the way in which you think about candidates for office. And you might start asking them, you want to adhere to the Constitution, or just think judges should just make it up as they go along?
Judge Ginsburg, thank you very much for a very interesting discussion of the Constitution and for your PBS series and the book. Thank you very much for upholding the honor of the class of '73 at the University of Chicago Law School. And thank you for your service to our country.
Thank you, David. You've done a great deal for our country. I'm really pleased and proud
Thank you.
of you.
Good night.
Good night.